just use the little raise your hand button and we can come in there and unmute your mic so we can take some questions. Stephen, do you have a hard stop for today that we should know about?
No, not today. I mean, we won't be going for 5 hours or something, but we'll get
Are
a
you sure?
reasonable stop
Are
at
you
some
sure?
point. But well, maybe with this crowd we will be. But
Right.
it's at some point I gotta go get dinner. But no, I don't have anything pressing until about 6:30 Central here.
All right. So we're good to go. We'll take a brief pause, check to see, Elena, we're good to go.
I think she's muted.
I think we are. I think I saw that she started the recording, and let's just go ahead and jump on in. So, welcome everybody to this episode of the GovCon Coffee and Issues podcast. My name is Carol Bernard, and I'm joined today by one of my favorite guests, Mr. Stephen Koprince, former attorney with Koprince Law LLC, and now he's just retired and enjoying the good life. And Stephen and I have gone back a long way, all the way back since 2012. And in fact, the topic of the day, which we're going to be talking a lot about joint ventures and some of the changes in the joint ventures and some of the changes that have occurred to the SBA's Mentor-Protégé program. It was back in about 2012, one of our first contracts as a business of Govology. We did a SBA teaming pilot program. And it was about that time where Stephen and I were working together to bring some education to the folks that were participating in that program. So after all this time, Stephen, I'm glad to welcome you back, and we're going to have another good discussion on joint ventures and the whole context of the SBA's Mentor-Protégé program.
Yeah, absolutely. Great to be here. I guess you and I have kind of seen this program grow up over the years. Back when we first started working together, the SBA really was only running the Mentor-Protégé program for 8 days, and then expanded to all small businesses. And of course, they changed their joint venture regulations considerably over the years, and in many different ways. And they're now proposing to do it again. These are complex rules, even though small businesses can get tripped up with them. So it's something that I've worked on in my legal career many times on the joint venture agreement side, on the Mentor-Protégé side, prime sub teaming agreements, etc. As you noted, I'm happily retired from legal practice now. I'm recovering attorney, as I say. Not here to give anybody legal advice, but I do keep a close eye on what's going on in that world still today, and very happy that everyone could join us to talk about the latest and greatest, and anything else that really that is relevant from the Mentor-Protégé side.
Awesome. Well, let's just dive right in. So we're here really to discuss a couple of potential changes that could really significantly impact the Mentor-Protégé program and joint ventures done within that MPP program as we know it today. And we also want to help to alleviate a little bit of confusion, because there was a couple of entries that were made by the SBA into the Federal Register. One is an officially proposed rule, and I'm going to be sharing some links to some of these things with you guys today. So there was an officially proposed rule titled Hub Zone Program Updates and Clarifications to Other Small Business Programs. So that's the official proposed rule. It's got a lot of information about some Hub Zone things in there. And if you're with us in our live Zoom session and you're going to be hanging out with us in our post-session Q&A, I'm sure Stephen will welcome a couple of questions as relates to what's in it with regards to Hub Zone. But we wanted to stay focused and on topic here with the SBA's Mentor-Protégé program and the joint ventures and what we see as potential issues and concerns within that. And then there's a second entry that was made into the Federal Register. Stephen calls it a floated rule, because it's not an official rule, even though if you go to the Federal Register, it appears to be a proposed rule, because at the top of the page it says proposed rule. But for the untrained eye, it's really not at this time, unless they've changed it recently, Stephen.
No, they haven't, and it has created a lot of confusion for folks, because there's two separate related but completely distinct items that SBA published in the Federal Register, and one of them, it's actually the second one. So the first one in line is this trial balloon that I call it. And the second was this proposed rule. And so back in July is when SBA went to the Federal Register and published what it calls a tribal consultation notice. And every so often, SBA does these meetings with the tribes, have a stake in 8A small businesses and hub zones, among other small businesses, to get feedback from the tribal communities as to how SBA can better serve those communities, what they're hearing, what they'd like to see, et cetera, et cetera. It's literally just that. I mean, the tribal consultation notice is intended to be, here's SBA saying, hey, tribes, we're going to have meetings in these 6 cities or wherever, nationwide. Here are the topics we'd like to discuss. Please come out and meet with us. Well, buried in that notice, SBA said, we're considering some prospective policy changes addressing mentor-protege joint ventures. And, you know, it, it was a it was not a well thought out way to introduce these concepts to the public for a couple reasons. Number one, because it was confusing the way it was published in the Federal Register with the words proposed rule. And it's not, I promise you, it's not a proposed rule. I suspect someone selected that from the drop down menu and selected it wrong. It does not comply with the Administrative Procedure Act requirements for a proposed rule. SBA later actually published a clarification in the Federal Register saying it's not a proposed rule. So you don't have to take my word for it. SBA says it's not a proposed rule, but SBA published in this tribal notification these ideas of, hey, we've seen some concerns out there about mentor-protege joint ventures, and we'd like to get feedback from tribes on some potential solutions. And it made it look like SBA was going to actually do this, so they were actually proposing to do it, which has not been proposed yet. These are just ideas that were floated. And second, made it look like they only wanted feedback from the tribes on this, whereas, of course, there's stakeholders throughout the community of government contracts who would be interested in that. And so I think it was a clunky, poorly thought out way to introduce these concepts, and it created a lot of confusion when a month later in August, SBA followed up with an actual proposed rule, which did not include the concepts that were in the tribal notification, but it had other issues, other proposals involving joint ventures. And so that has created a lot of uncertainty in the community about what exactly SBA is proposed to do, what SBA is just thinking about maybe doing and would like feedback on, and where things really stand with respect to joint ventures moving forward into the new fiscal year here.
Yeah, and I think, Stephen, that some of the confusion has come in, and what I've heard from some of the contractors is that, because I guess a lot of contractors follow some of the legal blogs that are out there, and as they're firing off these alerts and these different notifications, these two, one was the floated rule, which you just talked about, and then there was the other actual proposed rule. Both of them actually had some language in which it would impact the SBA's Mentor-Protégé program, affiliation exemptions, how agencies look at and evaluate potentially joint ventures. And so I think that's probably where some of the confusion came in. So this is also one of the things that we wanted to do within this session today, is really alleviate that confusion, because there's a public comment period for the proposed rule, which is titled Hub Zone Program Updates and clarifications to other small business programs, which is due in, well, the deadline for comment is October 7th. So we wanted to come in here to help alleviate that confusion, get you to the right notice here. And I'm posting this in the chat as well, which is the official notice there. And that way you can read through it, and by being able to ask some questions here of myself and of Stephen, and you'll be able to go in there and then maybe make your voice heard to the SBA over what you feel may be concerning to you inside of some of this language. So Stephen, I think that, for the purpose of probably staying focused on the topic at hand, which is really the more pressing issue right now, because I guess if they do propose what's in the floated rule, we could probably come back and have another coffee and issues segment just on what's happening in there, because there is some very concerning issues that could potentially impact the Mentor-Protégé program. But first of all, for those who have just come into this call today, and maybe they don't know about what the big deal is with the SBA's Mentor Protege program and what we're even talking about with these rules, maybe we can give them a little bit of like a context, Stephen. So if you could you talk just a little bit briefly? I know we've got whole webinars on these subjects, but like, what is the SBA's Mentor Protege program? Where did it start? Why was it implemented? And what have we seen in the way that it's changed, over the last decade to help small businesses in government contracting access opportunities that they might otherwise be locked out of because they don't have some of the experience and performance that the agency may be looking for.
Yeah, it's a good question. Obviously, we got a lot of folks here, and I appreciate everyone attending today. And people are coming at this, I'm sure, from very different levels of knowledge and sophistication. So it's good to just take a step back and either as a refresher for people who already are pretty confident about these subjects, or maybe an introduction for folks who are fairly new, kind of talk about what this program is, what it does, why it's so important for so many government contractors, small and large businesses alike. So, the roots of this program go back, 2000, early 2000s, I believe. And it was only for SBA's 8A firms originally. And so the government's been running a mentor protege program, at least with the DoD, since the 90s. We're not going to talk about that here today. That's a separate topic. But the SBA started one early 2000s, I believe, for its 8A firms. And I think the notion behind this program was, remember, the 8A track is a 9-year program under which the idea is to help disadvantaged businesses grow and develop to the point where they can compete on an equal footing in the federal government marketplace. And SBA, as part of that, tries to offer training and business development tools to its 8A companies. But I think that SBA at the time said, who better to help a small business grow and develop? In this case, they're thinking about 8A firms than a business that's already been there, a business that in many cases is a large business, or just a more successful, larger, more experienced small business, but somebody who's been down that road, who understands business because they've done it. And so SBA said, what would be really great is if we could convince these more successful, experienced contractors to mentor our 8A small businesses. Well, how do we do that? Some of them might sign up as mentors just because they get warm fuzzies from, hey, we were once small, we want to help somebody. But let's be realistic. I
But
mean,
not
these are
usually.
these are businesses, right? I mean, you're going to have a business motivation to get serious participation from the mentor perspective, and you know probably from the protege side too, because they have to put their trust in another business that could one day be a competitor, could be a competitor right now, for all we know. And so SBA thought this through and said, look, what we want to have is a program in which these larger, more experienced businesses agree to provide targeted business development assistance to the protege. We want the protege in the 8A. Every 8A firm has a 8A approved business development plan and says, here's how we want to develop our business during our term in the 8A program. And SBA said, well, using that business plan as the starting point, a mentor can say, we will help you meet these various needs in your business plan. And here's what we will do to help you meet these needs. And so if the protege needs to get a facility security clearance, well, maybe the mentor will sponsor the protege for a facility security clearance. Maybe the protege needs bonding to help it. It's a construction company and it's having trouble obtaining bonding that's of the level needed for larger projects. Well, the mentor can guarantee those bonds. Maybe the protege needs training writing proposals because they're not having a very high win rate. They're not doing a great job when they're out in the competitive marketplace. The mentor can provide that training. So the targeted to what the protege's individual needs are. What does the mentor get in return? In return, the mentor gets this special ability to joint venture. They get the warm fuzzies, of course, but they get this special ability to form joint ventures with the protege that are unique in the government contracting context. Because what a SBA joint venture is under this former 8A, and we'll talk about how that was expanded in a moment here. But what it does is it says when you have a joint venture, ordinarily, when you have a joint venture that goes after government contracts, two firms form a joint venture to go after a government contract. If that contract is restricted by size, that is, it's a small business set aside or it's any subspecies of small business set aside, such as 8A, hub zone, service disabled, veteran owned, woman owned small business. then both members of that joint venture have to be small businesses. That's the rule across the board. The only exception is the one that SBA created originally in its 8A Mentor-Protégé program. And that exception says that an SBA approved mentor and protege can form a joint venture to pursue any contract for which the protege qualifies by size and socioeconomic status, regardless of the mentor's size. And so that means now that mentors can be joint venture partners. That means part of the prime contract team, as opposed to maybe just being a subcontractor, for contracts for which they would not qualify because they're too big and or they don't have the socioeconomic certification in question. And that for many mentors is very appealing. Being part of the prime contract team often means they can do more work as a mentor than they would as a subcontractor. They can get more of the profits from the contract. They have more control over the contract because they have that direct relationship as part of the prime contract team with the government. By the same token, proteges often like these joint ventures because they can bring to their prime contract team this experienced, qualified mentor that can help the joint venture together, help that small business meet past performance requirements, meet technical requirements, all those sorts of things, as well as giving the government legal security, because under the joint venture format, both parties are legally responsible for finishing the whole contract. And so if the government's worried, hey, I don't know, small business X, we don't know if they can bite off a contract this size. What if they go belly up? Well, the mentor is legally responsible as a joint venture partner for finishing that contract. It gives the government extra security. Of course, a large business subcontractor or any subcontractor is not legally responsible for finishing the contract, as a subcontractor is limited to its scope of work. So the joint venture format is, for mentors, proteges, and the government alike, can be very appealing and can make the small business more competitive, can allow the mentor to access pieces of the federal marketplace that the mentor could not otherwise access at the prime contract level. That program proved very popular for 8A firms. A few years later, Congress authorized the SBA to expand that program to women-owned small businesses, as well as the subcategory of economically disadvantaged women-owned small businesses, to expand it to service-disabled veteran-owned small businesses, and to expand it to hub-zone small businesses. And while SBA was busy writing the rules to do that, to expand the program along the lines SBA suggested, or Congress had requested, Congress took another step in a separate bill and said, no, you know what? Forget that. Expand it to all small businesses. Make any protege who's a small business in its primary NAICS code or a secondary NAICS code in which it has experience eligible to be a protege. And so that was when SBA around 2016 created what was then called the All Small Mentor-Protégé program. That's the program that's essentially what we have today. It was later merged with the pre-existing 8A Mentor-Protégé program into what's now known as the SBA Mentor-Protégé program, which has all those elements that we just discussed. Going back, it has the ability for the parties to form joint ventures to pursue any contract for which the protege qualifies by size and socioeconomic status. Last check, there were about 1,800 mentor-protege pairs that were listed in the SBA's database who are taking advantage of this program, and under which the protege is getting that targeted business development assistance in exchange for, as the mentor gets the ability to form these joint ventures. And I've worked with, as I said, on many of these agreements, and with many of these companies who have formed them, and a lot of them have done very well with this as a competitive tool to access federal contracts.
Yeah, it's a really great program, and we've got some really great training on Govology. If you guys haven't really taken any of the training on the SBA's Mentor-Protégé program, as well as joint ventures, really encourage you to take a look at those, because it really provides you some strength. It really helps you get into some of these bigger contract vehicles as well, which is one of the points of contention in the floated rules. And maybe we can go into that a little bit later. Maybe we won't have enough time, but I think, Stephen, the issue that I'm kind of seeing here in some of this is that, since we've been working together since 2012, back when the SBA had their, teaming pilot program, and I was a part of that, one of the biggest challenges that I saw was that you're trying to put together teams of small business, and we're still trying to do that today through education, trying to educate businesses on how to do this. So once the businesses get the education, then you're saying, all right, let's go after this. one of the challenges that existed, which had changed, and it looks like this is now one of the proposed rules will kind of maybe undo this change a little bit. But one of the things that changed is that before, one of the hard parts was that you could do all of this work to put together the joint venture to get into the SBA's Mentor-Protégé program. You get to the opportunity, and the contracting officer in their evaluation criteria for award says, well, we want to see, certain experience and past performance held within the protege firm. Well, then that was challenged, because if that was the case, then, well, okay, you might not get that experience and everything counted. But then they came out with another rule that was part of, I'm going to read this out here. It was part of the 13 CFR 125.8 that basically came into effect, that stated that capabilities, past performance, and experience, when evaluating the capabilities, past performance, experience, business systems, and certifications of an entity submitting an offer for a contract set aside or reserved for small business as joint venture established pursuant to this section, a procuring activity must consider work done and qualifications held individually by each partner of the joint venture, as well as any work done by the joint venture itself previously. A procuring activity may not require the protege firm to individually meet the same evaluation or responsibility criteria as that required of other offerers generally. And then it goes on to say that the partners to the joint venture in the aggregate must demonstrate the past performance, experience, business systems, and certifications necessary to perform the contract. So I think when that regulation came into play, Stephen, that kind of gave the program a little bit more strength, and it gave a little bit more confidence to the firms that were doing all the work to form a joint venture, that, hey, if you got to the table with the agency and you made an offer, they were supposed to look at the experience, the past performance as the aggregate, not to kind of separate the two. Can you comment on that? Because that's where this
Yeah.
whole thing ties in, right? This specific language within this proposed rule is kind of going to step it back a little bit.
Yeah, I mean, I think the existing rule, I think, is a little bit ambiguous, and I think that's where things kind of stand right now. And so, you know, when SBA wrote the rule that Carol just read to you, one of the things SBA was trying to do at the front end was prevent agencies from requiring that the joint venture entity itself possess a certain level of past performance, because a joint venture entity under the SBA's rules is a limited duration entity. It's typically formed as a limited liability company. It's registered in SAM, but it doesn't have its own employees. It's called what unpopulated, and it essentially serves as a legal fiction by which two companies can collectively be the prime contractor. That's what it really does. It allows the government to take a single award contract and award it to two companies as the prime contractor under the guise of awarding it to this unpopulated joint venture. That's essentially what it is under current rules.
And unpopulated just means that it doesn't have employees.
Unpopulated means it doesn't have its own employees. It performs work through its members. So the members perform the joint venture's work on its behalf. And SBA essentially requires, and we won't go down the rabbit hole on this, but essentially requires all joint ventures to be unpopulated now. And SBA has what we call the 2-year rule. And the 2-year rule on joint ventures says that once a joint venture wins its first award, it has 2 years under which it can submit an unlimited now number of offers and can win those contracts or lose those contracts, whatever. But after 2 years, it has to stop submitting offers. So essentially, it has a 2-year shelf life of submitting offers, and then whatever it wins, it can perform out through contract close. But what that means is that a joint venture is a limited duration entity, and so it's not reasonable to expect that the joint venture limited duration entity has a lot of past performance itself. It is a separate legal entity. It's registered in SAM, et cetera. But the past performance is typically that of the members. So the joint venture may have another contract or two. That's not uncommon, but it probably doesn't have a lot. May often has zero. But the members themselves may be very experienced. And so when SBA wrote the rule that Carol read about, considering the capabilities of the partners of the joint venture or the members of the joint venture, one of the things they had in mind were situations in which the agency said, well, we know that, we've got highly experienced protege X and the mentor is, Booz Allen or, some giant firm, but this joint venture has no experience. So we're giving it a neutral, and just kind of ridiculous stuff like that. When you've got two highly qualified companies, or at least one highly qualified company there, it doesn't make any sense to say, to just disregard that. And so SBA said, look, you have to consider the past performance and experience of the members of the joint venture. And then SBA has in that regulation kind of sort of ambiguous or conflicting language. Remember, and I pulled up the rule here to read it to you again as well, the key pieces here. It says the procuring activity, that means whichever, the agency that's awarding the contract, may not require the protege firm to individually meet the same evaluation or responsibility criteria as that required of other offers generally. So from that's a little ambiguous. It says, but can you require the protege to meet some? I mean, if it's not the same, but could they require it to meet different criteria? I don't know. The next sentence says the partners to the joint venture in the aggregate must demonstrate the past performance experience, business systems, and certifications necessary to perform the contract, which sort of sounds like, at least to me, that if the mentor has $1 bazillion worth of contracting and the protege has zero, that the aggregate is still $1 bazillion, and so you get that benefit, maybe. And so the procuring agencies haven't quite known what to do with those sections. Some agencies, I think, have treated it as though that latter sentence is the more important. In other words, as long as the mentor is highly experienced and the protege gets the highest possible past performance ratings, even if the protege has zero experience at all. Other agencies have kind of looked at the sentence before where I said, remember, it can't require it to meet the same criteria, but they said, well, we're not going to require the protege to meet the same criteria, but we're going to require the protege to show some criteria, because the protege under the SBA's joint venture rules has to manage the contract and has to perform at least 40% of the joint venture's work. And so some agencies have said, look, I mean, it's nice that mentor X has $1 bazillion worth of experience, but the protege is the one running the show here and it has to perform at least 40%. So we'd like the protege to show some level of past performance here. And so there have been GAO bid protest decisions and court decisions kind of on both sides of the fence on this issue, and and I'm not going to run those to ground, but SBA ultimately has come in this proposed rule and said, you know what, GAO court agencies, we don't think any of you really understood our intent in this rule. And SBA in its proposal has really gone back to that sentence about not requiring the protege to meet the same evaluation criteria. They've emphasized that over the last sentence, or at least the reading of the last sentence, in which the aggregate just means everything added together. So what SBA has proposed now is essentially a clarification of the existing rule to say, agencies, you can require the protege to meet some level of past performance, but it has to be essentially less than you would require of other offers, right? And it has to be maybe somewhat correspondent to that 40% number. So if you're requiring everybody else to show a $10 million project, maybe you could require the protege to show a $4 million project. So that's where SBA has kind of come in. Keep in mind, this is a proposal, and SBA is undoubtedly going to hear from both sides on this. This is a proposed rule. This is one of those ones that's comments are due a week from now, or less than a week, on the 7th. And so they're undoubtedly going to hear from folks who say, yeah, that's not fair that I can lose a contract to a mentor protege joint venture where the protege is some startup that has no idea what it's doing, but the mentor has all this experience. And others who are going to say, well, that's not right to impose that requirement, since we should be able to take advantage of the fact that our mentor is super experienced and so we'll see where the final rule comes in. But SBA has essentially proposed to solve that ambiguity or almost conflict in its prior rule by emphasizing the piece where it said you can't require the protege to show the same criteria or past performance as everybody else, but now they're going to specifically say, but you can require some, you can require a lower level.
Yeah, and the concern I have with that, and the challenge that I see with that, Stephen, is again referencing the days back in the teaming pilot program. You know, it takes a while to do all of this work. To put together a joint venture, to get into the SBA's Mentor-Protégé program, to get the education that you need. That's where the starting point is, and then have the relationship, have the JV. So you do all of these things, and then basically you want to target a specific contract vehicle, maybe within the government, because you can't get in there on your own. But you don't know exactly what that contracting officer is going to put into SAM. And so, with a lot of like ambiguity and subjectivity, as I see it, the contracting officer may say, okay, hey, let's just take a MATOC, for example, for construction. Back when I was at the VA, we had like a $50 million MATOC. The task orders were to range from $2,000 all the way up to $2 million. What if there's a construction firm out there that's like, hey, you know what? I'm just like 150 to 500 is all I want, but you got to win this $50 million contract just to get to those. And what if the contracting officer comes in and there says, now, oh yeah, you got the JV, but let's just say that you can do 40% of and actually with the construction trades it's even more minuscule, because it's like 40% of a 25% requirement. The math gets mind-boggling, but it's just very confusing to understand, and to help contractors truly prepare for getting the win, because you really sometimes don't know until you see it posted on SAM. The agencies are not going to tell you, what they're going to use as maybe a grading criteria in enough time for you to get the joint venture in place. So it's kind of like, there's a bit of I think a problem that needs to be addressed some way, and I'm not sure exactly how it gets addressed, but I think it's unfair for these small businesses to get the education, to do all of the work, build the relationship, get the JV, set up the new entity, the whole 9 yards, only to find that one contracting officer is going to say, well, we're going to throw this in there. And because you don't meet that, well, that kind of nullifies all that work that you did over a year.
Yeah, I mean, there's a lot, and then I think, like I said, SBA is going to hear it on both sides here, and I think implied in your comments, first of all, is an important point, which is that, and I have heard this misunderstanding out there, so I do want to be clear. SBA's proposal, if it's adopted as is, does not require the any agency to insist that the protege have any level of experience. What SBA has done in its proposal is said the agencies can, if they wish, require the protege to show individually some level of experience capability that's less than it would be required if it was bidding on its own. And so it really does kick it back from a matter of SBA regulation to a matter of what an individual contracting officer, contracting activities chooses to put in the solicitation. Because you could see a solicitation in which the protege needs have zero relevant past performance, and they really do just consider the mentors to be good enough. Or you could see the opposite, where they say, hey, we want 10 million from everybody else and 4 million from a protege in terms of the size of a past performance project that has been performed, for example. And SBA, by the way, has promised to put in its regulations examples, if it goes through like this, of projects that, of how this would work, like this lower level of past performance experience or whatever. I am not a fly on the wall at SBA, but I will, if not play devil's advocate, tell you what I think is going on at SBA, because I think SBA is hearing from two constituencies here. Because I agree that there is certainly the argument to be made that, hey, you had to get the mentor-protege agreement approved. You had to negotiate that agreement. You had to find a mentor first if you're a protege, and that's often takes some time. You build a relationships, often subcontracting first. You find the mentor, you negotiate the mentor-protege agreement to get that targeted business development assistance. You apply, and SBA's current, last I checked a couple weeks ago, the current time frame they estimated was 105 days to get that approved. You can't joint venture until it's approved, so you got to wait that 105 days. You form your joint venture, you get it into SAM, you get it all registered, all those sorts of things. That's a lot of work. that you've done. And so, yeah, some folks are going to say, well, that stinks. I did all this work and put together this great joint venture agreement, but all I have is a $3 million project, and you want four. The flip side to that argument, I think, is the argument that, what about the small businesses that don't have mentor protege joint ventures, right? And because they
Yeah.
still have to show 10 million
Yeah.
because remember, these joint ventures are going after small business set aside contracts, 8A set asides, et cetera, et cetera. And so when SBA says the protege has to show a lower level, that's a lower level than other small businesses that are bidding on. So what I think SBA is hearing from some of these other small businesses that are saying, wait a second, if I have to show $10 million myself because I don't have a mentor protege joint venture, how can it be wrong to make the protege, who's also the small business over there that's teamed up already with the advantage of large business X in their corner, to have 4 million? Like, that seems reasonable to me, SBA. And so I suspect that, SBA is maybe caught between a couple constituencies here, because keep in mind, SBA exists to serve small businesses, and some of those small businesses have mentors and some don't. And so SBA is, I think, hearing from both of those constituencies. And I think when we talk about that tribal consultation notice, you'll see that I think pops up again. Maybe I'm wrong. Maybe none of this is happening, but I would be surprised. I think SBA is
Yeah.
hearing from both of those constituencies, and maybe in this instance is at least right now putting the thumb on the scale of the small businesses that don't have mentors, who are saying, wait a second here, if for set aside contract over here I have to show 10 million in past performance, how can it be unfair to make the mentor, or excuse me, the protege, show 4? Like, they already have a $6 million advantage over me. Why should it be a $10 million advantage? So
Hmm.
that's I suspect what SBA is hearing. And one's perspective on that is going to probably depend in large part as where you are in that market, keeping in mind that even if SBA's proposal goes through, and we will see if it does, that's still a big advantage for those proteges because they
Hmm.
now, even if the agency has required 4 million, yeah, that stinks if you have only 3 million in a project. But what if you have a $5 million project? Now you're in, whereas before you would have needed a 10 if you went in by yourself. So there's still a lot of value in the program, even if this rule were to go through. And so we'll see what happens to it. But as you can see, by those examples, the mentor, or excuse me, the protege business still has, even under this proposal, a substantial advantage over in terms of what type level of project it would need to show versus another small business that doesn't have a MP joint venture.
Yeah. Yeah. Good thoughts, Stephen. And for those of you guys who had come in late, we had been talking about the two, one officially proposed rule by the SBA that's set to make some potential changes to the SBA and the joint venture mentor protege program, and the other one, which was the tribal consultation notice, which we didn't really go into a lot here. So just to kind of recap, Stephen, the change that's kind of the biggest one, and that's in the proposed rule, really all it's doing is effectively saying it's just trying to basically clarify a little bit the existing rule that's at let me get that reference again, at 13 CFR 125.8, correct? And so it's just
Yeah.
saying that, like, well, they're going to now tell the agencies that, hey, instead of you being required to accept the aggregate of everybody's past experience and past performances, one, they will allow for you to say you want to basically require something of the protege to show experience and past performance. Actually, they don't say experience even. I
Right.
noticed that they left that out, which it's
Yeah, it
different than,
says past performance, and
yeah.
I mean, it's interesting too, because when you have what they just put a level, like you have to have a $10 million project or whatever. A lot of agencies are kind of wary about that sort of thing. Those, what they call definitive responsibility requirements, because those can be deemed unduly restrictive. They can, sometimes, depending on how it's done, it can even let the small business get what's called a certificate of competency review from the SBA. And so I don't know how many times you're going to see like a specific dollar value. You will see it sometimes. You do see those criteria sometimes, but a lot of times, agencies are a little looser on their past performance requirements than just, it has to be this dollar, it has to be $20 million if it's 19.99999 million you're out. I mean, so it's often more of a sliding scale of relevancy and that sort of thing. But we'll see. But yeah, that's where the SBA is proposing to come down on that particular rule. I guess they would deem it a clarification. I think that's right because, like I said, that regulation is debatable. It's a little ambiguous. It's maybe a little internally inconsistent. And the fact is that the federal courts, procuring agencies, and the GAO have all sort of looked at it and said we're not quite sure what to do with this. So I think it's a good idea for SBA to clarify it. Whether an individual small business or large business mentor agrees with that way that's being clarified or proposed to be clarified, of course, is going to be a matter of where that company stands in the market, I think.
Yeah, I'm just posting to the chat here the comment box there for that specific proposed rule. And again, I'm going to post the link to the proposed rule here in the chat. And again, for those of you guys who joined us late, there's a couple of different things that's published in the Federal Register. The one official proposed rule that we have been talking about, the deadline for submitting comments is on October 7th. So you've got the link to that proposed rule. If you're joining us not in the chat here with us, just kind of go in Google HubZone program updates and clarifications SBA proposed rule. You should be able to find and read it in the Federal Register there. So what we're wanting to do is just encourage everybody to make your voice heard, right? Whether you're on one side or the other, make your case for this. Then there's a second floated rule, which is under the tribal consultation. That's not an official proposed rule. And that rule in particular has maybe some even more concerning changes, I guess, for the joint ventures within the SBA's Mentor-Protégé program. You want to kind of talk about those very briefly and what your concerns may be on those?
Yeah, and so this is important, and this did get people up in arms to the point where, as I mentioned, SBA about a month later came out and officially posted in the Federal Register saying this is not a proposed rule. We are just kind of taking the temperature of everybody on this. We're not proposing to make these changes right now. If we do so, we will do it through a formal rulemaking process, et cetera, et cetera. But this is still very important to know about because it tells you what SBA is thinking, and so SBA in this tribal notification, and again, my opinion, this is not well handled from an outreach perspective because it just didn't look good to bury this in a notice just to tribes when it impacts so many others. But be that as it may, what SBA said in their tribal consultation notice was, there's this perception out there, and they use the word perception several times, that Mentor-Protégé joint ventures are winning in a quote unquote inordinate number of orders under multiple award contracts. That when you have a multiple award contract, that Mentor-Protégé joint ventures are essentially too powerful, and they're winning too many of the awards. And we're seeking comments on whether that's the case, and how small businesses who are competing that aren't Mentor-Protégé joint ventures can more effectively compete against these joint ventures. And the SBA also says, we are also concerned about the perception. And again, I keep using these quotes because the SBA uses the word perception repeatedly in this tribal consultation notes, but doesn't provide any facts. It just says we have a perception that this is what's going on. But a perception that agencies on these multiple award small business contracts are imposing stricter requirements, past performance and experience requirements specifically, than they otherwise would, because they're getting a lot of bids from Mentor-Protégé joint ventures. Thereby, small businesses that don't have a mentor or don't have the right mentor even don't meet requirements simply because the requirements are higher than they otherwise would be due to the participation of Mentor-Protégé joint ventures in those competitions. And so SBA says we're actually floating two ideas, SBA says, to address this perceived problem. And again, they say it's a perception. One would simply be to not allow Mentor-Protégé joint ventures to go after small business multiple award contracts, period. That's big.
Yeah.
Multiple award contracts, large and small business multiple award contracts are about a quarter of federal spending in the
Yeah.
last fiscal year, I believe. So that's a lot.
And in
That's
some
a lot of
industries like construction, I
yeah.
mean, you may find that like, hey, if the agency has an indefinite delivery contract for construction, they might be doing 90% of their work through there.
That's right. And
You
other,
know?
there are other industries where, some of these big multiple award vehicles are really important for folks to be on. And so that would be a big big change if SBA made it. And the other change SBA proposed as an alternative, and this is another way you know that it's not a formal proposal, because SBA is like, which one of these should we do, if either, was that Mentor-Protégé joint ventures would be ineligible for any contract, whether single award or multiple award, as I understand it, that exceeds 5 years in duration, 5 years being the general lifespan of a single award contract that's for services, something like that, under the appropriations rules. And so, you know, again, my main concern here is where's the data? I mean, again, my feeling is that SBA is saying this because they're hearing from certain small businesses that don't have
Yeah.
mentors that, hey, this is making us really hard to compete. But I participated in a Mentor-Protégé event in DC last week, and one of the organizers had actually put together data on, I think it was 4 of the larger small business multiple award contracts that showed that, in some cases, Mentor-Protégé joint ventures were, receiving awards greater than their participation level. In one case, I believe it was lower than, but in no case did they seem to be like completely nuts. Like, hey, the 18% of the awardees are Mentor-Protégé joint ventures and they're getting 26% of the awards or something. So in no case, at least in the examples that I saw there, did it seem that there's necessarily an inordinate amount of work going to Mentor-Protégé joint ventures. I do suspect that, SBA, I know, has heard on both sides of this already, even though that's not a formal rulemaking proposal yet. I do suspect that if they were to try to go forward, or to move forward with this in any official capacity to a proposed rule, they would need to present statistics. I mean, that's the
Yeah.
first thing, because people say, what's your opinion on it? I'm like, well, first show me the numbers. Like, is it just a perception, or is it really true that these Mentor-Protégé joint ventures are winning more work? Is it just a perception that the evaluation criteria are stricter than they used to be before we had this program in place, or is it not? Someone show me the numbers, show me the comparison, and then I can give you my informed judgment as to whether these changes make any sense or not. Although they, even if the numbers are out, excluding Mentor-Protégé joint ventures seems like an awfully aggressive stand. But I'd like to see the numbers on this stuff, and so I don't know if this will go forward at all. It may be that SBA has heard enough from Mentor-Protégé joint ventures who are flipping out, saying no, don't do this. But it's important for folks to know that this is going on. That SBA has been hearing this, I think, from companies that don't have these joint ventures, and is thinking about whether we actually reduce the power of our own program, which you don't often see agencies
Yeah.
do that. But that's what they're thinking about doing.
Yeah, and that particular notice I had posted up in the chat here. But again, if you guys are just joining us from Facebook or YouTube feed, if you want to find that one, again, that one is titled "Tribal Consultation for Hub Zone Program Updates and Clarifications and Potential Reforms under Executive Order 14112." So you probably could just Google tribal consultation, Federal Register, you might find it like that. That is the one that is the floated rule that Stephen was talking about. That one is the one that has got some of the language that's even more concerning than the actual proposed rule. And I will just put one of my other concerns out there, and maybe it's an issue that I see with this, Stephen. I believe that the federal government, and I used to be a contracting officer and I worked in procurement a lot, and we go through a lot of links to ensure that we're not giving one contractor an advantage that another contractor doesn't have. And I see when you put these programs out there and people go through to get the education to understand it and to make use of it, and they benefit from it, then they get into these big contract vehicles. Well, now they are the incumbent, and there's been some studies that has said that incumbents are typically already have a 60 to 90% advantage over people coming in to the contract new. So if you're trying to get into one of these contract vehicles, and now you're competing up against a incumbent that actually was allowed to come in with a bigger partner under the rules, if they take away the rules to remove that exemption or whatever. I just see it's a challenge for the new firms that they don't get that same advantage. But those firms that were able to get in, now they gather up all of that experience and past performance that is going to be a competitive advantage to them in the future. So that opens up a whole other can of worms, I think. But anyway, I just wish that it would just be like, hey, these programs are open. Here's the rules. Here's what they are. And everybody can learn the rules and take advantage of them. Or, they probably shouldn't have done it in the first place to begin with.
Well,
So,
and I mean, I think so many folks have benefited from this program. Like I said, I was
right.
part of a panel last week in DC, and there were a couple small business owners there. One was now a large business mentor, and one was a small business, and they'd both done very well with this program, both when they were
Yeah,
small and growing to large, and learned a lot, gained a lot from it, won a lot of work from it, and so eh, it's tough. I mean, SBA has a large constituency to represent, and they're not everyone's in the same
absolutely.
position. But you can also say, hey, if you can't beat them, join them. I mean,
Yeah,
there's that mindset too. But that's sometimes easier said than done. Not everyone has
yeah,
that relationship with a good prospective mentor to go in and do that. But yeah, I think there's a lot to be um, a lot to be thought through as SBA is going down the road of this program, especially when it comes to any changes that might really significantly weaken the program. I would say based on the proposed rule, which does at least clarify that past performance issue and a few other items, but it don't really appear overall, other than depending on your position on the past performance, to weaken the program. It is still a powerful program for mentors and
absolutely.
proteges
Yeah,
alike, and so one of my fellow panelists last week said, something to the effect of, don't worry about what SBA might do a few years down the road. Like, just
yeah,
take advantage of the program now. It's great, and
that's
that's,
right.
I think that's the right
The
mindset.
power of
Keeping in,
now.
yeah, absolutely. And we don't know. I mean, there could be a brand new administration in January. I mean, we don't,
Yeah,
there will be a brand new administration, and just whether it's a really really new administration or not will remains to be seen. But those, the change, and there'll be a new Congress too, and
yeah.
so the the mindset of SBA could change with respect to some of the stuff overnight, depending on what happens in November elections as well.
Yeah, that's the best advice I could give is just, hey, keep following us, on the blogs and on the education that we're putting out there because, it changes almost every year. And it's important for you guys to understand what changes are happening because that'll either present an opportunity or a threat to your business. And so you got to stay abreast of the changes if you're going to be in the federal contracting world. I think that that's a key takeaway. So,
Yeah, I mean, 100%. I mean, I had somebody reach out to me not long ago and said, "Hey, when I'm done with the current, book I'm reading, I'm going to read your book next." And I said, "My book was published in 2012. Don't read it because it was a great book when it was written, if I do say so myself. But it was all about the rules for small businesses and government contracting as they were in 2012, right? And
yeah,
so we're 12 years later, and there've been so many changes that book is just not a viable source of information anymore for a small business. So I said, as much as I hate to say it, don't read my old book because it's just the rules have changed so much. So yeah, it is one of those industries where things are constantly changing. You got to keep on top of what's going on, and also keeping on top of what could happen or what's proposed to happen can help you make smart business decisions moving forward as well.
yeah. There's just one thing I want to leave off with, and then we'll take some questions. And Stephen, it's again goes back to the floated rule under the tribal consultation. Um, so that one doesn't really have like a link to put in the comment box, but if you read the proposed floated rule there, there is a point of contact, and you can email the point of contact, or you could do snail mail to submit your comments. And one thing you mentioned to me when we were kind of talking about this initially is that you would encourage contractors to use that as well, even though it's not an officially proposed rule, but they can still reach out and let their voice be heard, and that might shape a lot the way that turns into a proposed rule or not in the future. Correct?
Yeah, I think so. I mean, there's nothing to be lost by politely, no, not a million exclamation points, caps locks, and naughty words, but politely reaching out to SBA and letting them know, hey, I'm a small business, and here's what I think. And you can do that formally through the regulatory, for the proposed rule through that process, and you should. In my experience, SBA does, in fact, read through the public comments and respond to them and think about them, and sometimes changes its mind or goes a different direction because of comments it gets from its constituency, which is small businesses, American small businesses. So go do that. But even for the floated rules, that's stuff that there is no formal comment process for that right now because it's not a formal rulemaking under the Administrative Procedure Act. But SBA is clearly thinking about these things. They've already received comments in their meetings from tribes on that, and there's nothing stopping you from politely reaching out and saying, hey, I just wanted to put my 2 cents in on this one because it would really impact me, and let them know what you're thinking. And yeah, I mean, these are folks who are going to make the decision whether they want to advance this ball to proposed rule some point in the future. At this point, I don't, if this were to become a law, it probably wouldn't be till like 2026 at the earliest, going through the process of turning it into a proposed rule and then a final rule.
Mhm.
But who knows? You get enough feedback from commenters who say we don't want this, or here's a better way to do this, or please show me the math before the numbers before you just assume that there's this inordinate number of MPJV awards, whatever your comment may be, and maybe you have a different perspective. But let the SBA know politely as always, but let them know because
Yeah.
there's nothing to be lost by doing that. There's potentially something to be gained by it. And like I said, with respect to the regulatory process and the formal comments, my experience is SBA does uh, consider those. They do read them. They are good at doing that and actually considering what the small business community has to say, which is
Yeah.
something in SBA's favor.
Yeah. One of the things I was hoping to help out with here, Stephen, and thank you so much again for participating in this with me. But again, is to make that distinction that there are two separate entries in the Federal Register. And this is just a recap here. One titled Hub Zone Program Updates and Clarifications to Other Small Business Programs. There's an official proposed rule, an official comment period in that. So I encourage you guys to read all of that. There's a lot more into it than just what we talked about here. If you have comments to make to the SBA, I would suggest keep them focused to that specific rule. And then there's the second one that we were talking about, which is the tribal consultation for hub zone program updates and clarifications and potential reforms under Executive Order 14112. That one is not an official proposed rule as of yet, but there is a point of contact if you wish to submit comments on that particular any issues or concerns that you see inside of that. We encourage you to address those inside of that, but I wouldn't mix up the two, so that you don't want to waste your comment period with something that might concern you in the first rule with a bunch of things that's unrelated in the second one. So
Yeah, absolutely agree. I mean, I think, when you're going in to do those formal comments in the SBA's proposed rule, if you decide to do that, yes, limited to what's in the four corners, as we lawyers say, of that rule. That does a couple things. Number one, it prevents SBA from just saying, no, irrelevant, not going to consider it, which they get a lot of those comments from people who just say I don't like it, and they're like, okay, I guess we'll count you toward the don't like it. But and if that's all you have to say, that's great. But if you don't give any reasons, they don't really have to give it much thought. They're just like, well, there's a vote against, but you didn't really tell us how it can be improved or what you don't like. Like, it's not a very helpful comment. And it also shows SBA that you know what you're talking about, that you are somebody who's paying close enough attention to understand that there are two different things out there. One's a proposed rule and one's a trial balloon, or one's a something that was floated. And so I think if I were reading comments and from somebody who was very clear they understood that, I would be like, oh, here's an educated person whose comments maybe I'm going to take a little more seriously. Maybe I wouldn't say that overtly, but subconsciously that may be what I would be thinking.
Yep, absolutely. Well, Stephen, thank you. That concludes this part of the Coffee and Issues show. For those of you guys who are sticking around with us in the Q&A, we'll take some live questions. And if you would like to ask your question live, Stephen, you could do your little raise your hand and we'll unmute your mic and open up for questions. But we do have a few that was posted in the comments as well as in the Q&A box, Stephen. So I'll read some of these to you. And I can answer some of the ones as well, like how do I actually become a member of the MPP program? I would encourage you to go to Govology and watch the webinars that we have on the Mentor-Protégé program. It's an SBA program that we've been talking about. A lot of the other federal agencies have mentor-protege programs, but they don't work and act the same as the one that we've been talking about, which is the SBA's mentor-protege program. So I would encourage you guys to go and take a look there, because we've got a whole webinar on that subject. But I would really encourage you guys to look at it. As we mentioned, these programs are very powerful, especially when a team or a joint venture is done within the confines of the mentor-protege program for the SBA, because it allows for some special rules that don't apply outside of it, which is you can't joint venture with a larger firm if you're a small business outside of the MPP program, but you can within it. That's kind of the simple point there. Let's see what else we have. We have an approved SBA MPP, but not a JV. Would adding an SBA approved JV only be associated with our 8A?
So yeah, so I mean, again, I can't give you individualized legal advice. That's not what I'm here to do, but I will tell you what the rules are right now. So a mentor-protege agreement does not create a joint venture. Just for anybody who's confused on that subject, a mentor-protege agreement, once that's approved by SBA, the mentor-protege agreement is a business development assistance agreement. It is essentially a three-party agreement under which the mentor agrees to provide targeted business development to the protege with the blessing of the SBA or another agency if it's another agency's program. But we're not going to talk about other agency mentor-protege programs here. More than 90% of federal mentor-protege pairs, by the way, are under the SBA's program, by far the most popular mentor-protege program. So you have if you have a mentor-protege agreement set up, then you have a business development agreement in place, but it's not a joint venture, it's not a team. And so those things are sometimes confused that, okay, I've got my mentor-protege agreement, now I'm going to go bid some stuff. But to bid as a mentor-protege joint venture, you have to separately form a joint venture. Under the rules, the joint venture is ordinarily going to be unpopulated. That means it's not going to have employees of its own. Most folks choose to set them up as limited liability companies, LLCs. They have to be separately registered in SAM. And so the joint venture is itself separately registered in SAM. The SBA does not approve joint ventures, pre-approve joint ventures, except the joint venture agreement, because you have to form a joint venture using a joint venture agreement. The SBA does not pre-approve those agreements except for 8A sole source contracts. 8A sole source contracts. If you're going to go after an 8A sole source contract, the SBA has to pre-approve your joint venture agreement. That means make sure that the joint venture agreement meets all the regulatory criteria that exist for those JVs. I highly recommend that if you are going to form a joint venture, you get an experienced government contracts lawyer to help you with that process. And I am not trying to sell my own services because, like I said, I'm retired. I can offer recommendations for folks who I know and trust who could do that work for you. I don't get paid for those recommendations either. I'm just saying this because it's what you need to do. Why? Because a joint venture agreement has, under the SBA's rules, has about 12 to 16 mandatory criteria. Those criteria can vary depending on what type of contract you're going after. Small business set aside, hub zone, 8A, etc. If your joint venture agreement does not meet one of the regulatory criteria and you are awarded a contract and a competitor challenges that award, you lose your contract, period. You don't get a chance to revise your joint venture agreement to meet the criteria. That's the downside of SBA not pre-approving, by the way. Because if the SBA on an 8A sole source looks at your joint venture agreement and says, you know what, you missed the boat on a couple of these criteria, they'll probably send you back the agreement and you get to fix it, probably. But you say, well, good, it's a small business set-aside contract. SBA doesn't have to approve my joint venture agreement, and you missed the boat on one or two of those criteria that are mandatory criteria in the regulation. Again, depending on how you look at sub-criteria, maybe 16 or so criteria, and you missed one or two of them, you get challenged, the contract goes away. You can fix your joint venture agreement for the next contract, but that joint venture agreement is frozen in place as of the date you bid it. You can't change it afterwards with respect to that opportunity. So if you could afford it, and most mentor-protege joint ventures should be able to, because if nothing else, the mentor has hopefully some resources, have a SBA attorney, an experienced government contracts attorney who does this sort of stuff, carefully review your joint venture agreement or draft it for you from the get-go, so that you don't end up, because I can't tell you how many times as an attorney, it's the worst type of conversation to have as an attorney, is when the client calls up and they say, our award just got protested. We're a joint venture. I don't know this person. They're new prospective client. Our award just got protested. We're a joint venture. Can you help me defend the award? I look at the joint venture agreement. It's wrong. And I say, no, there's nothing I can do. Like, you'd be wasting
Yeah.
your money to hire me. And that's a tough conversation. There's nothing any lawyer can do. So those are my 2 cents there. But to get back to the question, yeah, as far as SBA pre-approving the joint venture only after for 8A sole source contracts, used to be for 8A set asides as well, but they removed that requirement maybe 3 years ago.
Yeah. And I concur with Stephen, and I mention that all the time, utilize a good GovCon attorney that specializes in this stuff, that eats, sleeps, and breathes this every day, because I mean, even as much as I do this, it's really hard for me to keep up with things sometimes. And then fortunately I have Stephen. I'm like, Stephen, what are they talking about here?
Yeah, I mean, and people are trying to run their business. I mean, yeah, so I mean, I spent 16, 17 years doing just that. And
Yeah.
I can't imagine trying to keep on top of all this stuff, plus run a business,
Eh,
plus do your own legal work by writing joint venture agreements. I mean,
yeah.
yeah, don't do it yourself lawyer stuff. I mean, that's not, you wouldn't do it yourself, your own dental work or something. Don't be a
Yeah.
DIY lawyer. That's my 2 cents there.
Yeah. We had a couple of questions about, like, is the MPP different than the 8A program? Really, it is just a benefit for small businesses. It used to be a part of the benefit exclusively to 8A contractors, but now it's all small mentor-protege programs. So if you're a small business, you can take advantage of that program. We've got some training at Givology that would be very helpful to you in trying to understand really what it is. We had another question, Stephen, that had come in about if you're in an SBA MPP 8A JV with a tribally owned company, do these changes apply?
Yeah, I mean, they would apply to anybody if as they go through. There's no these changes that the SBA has proposed, at least in its proposed rule, are the same for any mentor protege joint venture. As far as I can recall, they don't make any distinction based on whether the mentor is or is not a tribally owned entity.
Yeah. Let's see what else we have here. All right. What are your thoughts about an evaluator asking how often the protege and mentor have worked together on projects during an interview when this requirement was not evaluation criteria in the solicitation? Does this also relate back to the proposed rule?
Yeah, I mean, I can't really answer that. It sounds really specific to someone's individual situation. So
Yeah.
I don't want to be walking down the road of giving you legal advice about what may or may not be unstated evaluation criteria or anything like that.
I,
That's
I think a,
yeah, good to I have to call an attorney about that. I'm sorry.
I think a good question that might relate to this, Stephen, that could be applicable to everyone, is that you may see in a solicitation where the agency might have, and this has been some things that we've seen in the past, where the agency puts in language that they say, well, we want to see that you guys have done projects together as an entity to apply the past experience and past performance to this particular solicitation, right?
Yeah, I mean, I've seen those kinds of evaluation criteria before, and I've even seen it with not just mentor protege, but I've seen it with prime sub teams. Like, show us you've worked together before.
Right.
If you're going to present a major teammate or whatever they call a significant teammate, we want to see that you've worked together, presumably in some cases because the same contracting office has seen cases in which the team blew up because they'd stopped getting along or whatever. They had issues together and it affected their ability to complete the project. That would be my guess
Mm-hmm.
in certain cases. So yeah, it wouldn't be unusual necessarily to see that. The extent to which an agency could ask that when it wasn't in the solicitation is really one, like I said, I would kick that to a government contracts attorney to take a look at what that solicitation actually said and whether that's, quote unquote, unstated evaluation criteria or logically encompassed within the terms of the solicitation, that sort of stuff. And that's farther than I'm willing or able to go in a setting like this. But I would encourage you to have that discussion if you're thinking about a protest or a challenge of some sort with government contracts attorney.
All righty. So here's another one. Is there a best practice for mentor protege for which party is the managing partner, or is it mandatory for one party to be the managing partner? That's a good one.
Yeah, so the protege has to be the managing partner. So the Mentor-Protégé joint venture, remember the Mentor-Protégé itself is not managed by anybody. It's a business development agreement. But assuming we're talking about the joint venture, the SBA rules, and I mentioned those, 16 criteria or whatever, do speak to that. They first of all say that when you have that legal entity, which in most cases is a limited liability company, the protege needs to own at least 51%. So almost all these are 51%, 49% equity stake. And then among the many other rules, they say the protege needs to be what's called the managing venturer or managing member of that entity, and that the employee of the protege essentially needs to be the highest officer responsible for, for running the contract that the company is going to perform. So again, each joint venture that you would form will have that criteria of SBA regulations. That is, and again, there are 5 sets of regulations. So keep in mind that there's a regulation for small business set asides, one for 8A, one for SDVOSB and VOSB, service stable veteran owned small business and veteran owned. There's one for women owned small business and EDWSB, and there's one for hub zone. So you want to make sure that your joint venture agreement meets the rules for the type of contract that you are trying to pursue. And those rules do speak to ownership and management of the JV, among many other topics as well, bank accounts and, performance of the contract and things like that.
And we got another question. What if certain solicitations could be set aside for only JVs in an MPP and who could only bid and forbidden from others? Is that a viable solution?
Yeah, I mean, I don't know that there's any far to my knowledge, federal acquisition regulation does not speak to that issue. Whether that means it could be done or couldn't be done, is an interesting question. I haven't seen anyone attempt that before. I know that idea has been floated out there as at least as like a Mentor-Protégé joint venture track on some of these GWACs or other type of multiple award contracts, so that you say, well, if we think that these MPJVs, Mentor-Protégé joint ventures, are winning an inordinate amount of contracts bidding against regular small businesses, then let's give them their own track to bid like against like. I think the flip side of that argument is, well, then, okay, well, maybe the small business just chooses to bid the small business track. Why would I want, I'm not getting an advantage anymore. I don't know. Well, yeah. we'll see. I have not seen anyone. It doesn't mean it hasn't been done, but I have not seen anyone in the federal government attempt to do some sort of set aside solicitation or track for joint ventures or Mentor-Protégé joint ventures. That said, it's not actually the first time I've heard that idea floated as a potential way to mitigate any concerns about, our joint ventures truly winning inordinate amounts of contracts. Is it fair to have them competing in the same track as quote unquote regular small businesses? Is that increasing the standards to which agencies are evaluating past performance, capabilities, et cetera? Could we not just give them a separate track or a separate vehicle even and let them go? It's an interesting idea. I haven't seen it, but it's an interesting idea. And, that might be a comment to make to SBA, because, like I said, I don't know of anything in the FAR or SBA regulations that would either allow or disallow that type of set aside. And one could probably make a legal argument both ways on whether you could do that. But if the SBA wrote a rule that said you could do it, well, then you can do it. And so who knows, maybe giving that idea to SBA would give them some food for thought as they are moving forward with these potential changes.
Yeah, absolutely. So I think most of the other questions are kind of like repeats of the other questions. And I think some of them is things that we covered earlier, and we did a recap just to kind of go back for the people who joined late. So if you guys still have questions, please go and check out. Yes, we will be posting this to YouTube and some of our other channels, podcasting channels and whatnot. So you can go back and take a listen to it. But one thing I want to leave everyone with here is that there seems like to me, Stephen, that there was a lot of folks coming in who, might not have really even understood what the MPP program was, what the JV program was. I think the best guidance that I could give you guys is to go and take some of the training that we have at Govology. Go to our on-demand library and look for SBA Mentor-Protégé as a keyword, and that should bring you up some courses. also joint ventures, anything with joint ventures, and take all the training that you can. There's a lot of nuances to these rules and a lot of exceptions, but there's a lot of power inside of what the program allows you to do as a small business in teaming up and getting the support from larger businesses out there. And so, I know that there, like we talked about here today, there could be a good case that could be made, for the benefit of it, and there could be probably some that argue against it. When if you can't manage to make the program work for you, or if you can't find the big partner to go into some of these contracts with. And maybe some of the answer is that we continue to have a conversation together, and maybe even get some of the folks involved in contracting communities and folks that are making decisions at that level, because I think some of the competition or some of the ways that it's hard to compete may not necessarily always be because of these structures. These structures help people get access to a lot of contracts that are just really way out of the ballpark for most small businesses to compete in the first place. And so I think there could be some ways to figure out how the government can reduce some of these like very high bars that they set on some of these contracts, but at the same point in time, you're doing business with the government, and you're doing business with the Department of Defense. I mean, some of these things are very critical that they get what they need, and the small business programs kind of become secondary in nature to some of the other missions that the agencies have to fill. So we always have to take that with a grain of salt. But I kind of feel like Jerry Springer now and rambling off in my final thoughts. But
Yeah. So I
Stephen,
think
I'll give you the final word.
yeah, and so for those of you who are kind of new to the idea of the Mentor-Protégé program and are looking for training on that, as Carol said, we do have some training that I just did actually about 2 weeks ago here on Gavaldi. I'm going to go ahead and put this in the chat if I can
Yeah,
here.
thank you.
Let's see if I can get this even set aside here. Hang on a second. Let's see if I'm able to get that in the chat, or maybe we'll have to do it.
You should be able to. I think we've
Yeah, my
enabled it,
computer's
Stephen.
acting up here, so I'm just having trouble cutting and pasting it. But we just did this, and I about on September 17th, and so
I'll grab it
what
and
that
post it in
program
the
is
chat.
called, and maybe you can get in the chat, because my computer's just having trouble doing the cut and paste on it. But it's in the Govology's on demand section, and and that is really it's called Maximize Your Potential with the SBA's Mentor-Protégé program, and that is we start with big picture. What is the Mentor-Protégé program? Where does it come from? Who's eligible to be a protege? Who's eligible to be a mentor? What does it mean to form a joint venture? What the application process look like? We talk about this various steps in the application process and the timeline of what that looks like, and then unpack some of the major misconceptions about the program and offer you the resources and the links to go ahead and proceed with that program if you're interested in applying or finding out more from the SBA's website. So, that one, like I said, it's fresh off the presses, right? Hot off the presses. I mean, this is a program that we did just about 2 weeks ago that I taught. So if you're like, hey, I could stand to hear that Coprin's guy a little bit more. This is a more structured program, kind of starting from the big picture, and again walking through the eligibility criteria, the joint ventures, timeline, the application process, and all that sort of stuff. So if you're new or somewhat new to this, I think that would be a fantastic resource. I'm obviously biased, but I think I think it's a great resource for those who are looking to kind of learn about the program, what it is, and whether it might be right for them.
Yeah, and remember, everyone, that it's you don't just jump into a JV, you don't just jump into the MPP. You got to think with the end in mind. What is the end goal? And it usually revolves around a specific opportunity that you want to pursue and you want to win. Once you identify that, we talk a lot in some of our webinars about forecasting and seeing opportunities like, 2 or 3 or 5 years down the road. So when you see those opportunities and you're able to study them and you see that, like, hey, there's no way that we can win this on our own, we need a partner. And that's when you start to come back to, all right, how can this MPP program help me? how can maybe, having a joint venture specifically to go and win that opportunity within the constructs of the MPP program give us more leverage and more competitive advantage to get ourselves uh, either in a contract vehicle or to help us be more competitive. So, and I think
Yeah, the
that's the end.
forecasting is really
Yeah.
important because, as we said, I mentioned in passing earlier, the SBA current estimate is it takes more than 100 days to put together a mentor-protégé agreement. So if you're saying, hey, there's an opportunity coming in 45 days,
Yeah.
and we want to do a joint venture, but we don't have a mentor-protégé agreement in place yet, that's probably not going to happen. And so
Yeah.
being able to do that forecasting and say, hey, here's an opportunity that's coming next year or 6 months down
Yeah.
the road, that gives you enough time to find that potential mentor, have those negotiations about the agreement, get it submitted, get it approved, get the joint venture
Yeah.
set up, and all those sorts of things. But it's not a process that can be used really at the last minute.
Yeah, and we have another really great training program. It's a 10-week cohort-based program that we run with some of our partners, and we're also going to be launching a version of it here in the spring sometime. So it's kind of designed to kind of give you that, like, each step of the way of the program. You'll learn about teaming, you'll learn about forecasting, but the one thing that you want to take away is that if all you're doing is watching things come from Sam, you're going to be very limited in your ability to get some of these bigger contracts because, just like Stephen was saying, it takes time, and usually the solicitation window from the time it's open to the time it's closed is well too short to be able to have a relationship with a potential partner to get into the Mentor-Protégé program, to form a joint venture, get it registered in SAM, and make it eligible for award under this whole thing. So there's a lot to it, but that's why we are here doing the education. And again, Stephen, thank you so much for being a part of this. I never would want to do this without you. It's just there's so much information in your brain. I wish I could just pull it out all the time. So, but
I
thank you
just
so
spend way
much.
too much of my time reading about this stuff and talking about this stuff. But no, it's always a pleasure, Carol. Thanks so much for having me. Thank you for everyone who stuck with us here. It's been a lot of information flying around about this, but really appreciate everyone who came. And of course, if you're listening to this later in the recorded session, thank you for watching as well.
All right. Well, that concludes this episode of Coffee and Issues. We'll see you next time. Thanks for joining us.
Thank you.